Welcome to our third lecture on disability discrimination. We're going to start the second half of the PowerPoints that we have for this particular chapter, so let's begin. In our first two lectures, we covered the introduction to the topic of disability discrimination. We discussed how the plaintiff presents his or her prima facie case, and we talked a lot about key vocabulary terms. The main ones that we talked about were disability, major life activity, otherwise qualified or qualification, essential functions, direct threat, reasonable accommodation, and undue hardship. In this presentation, we're going to focus on the reasonable accommodation process, as well as special categories of disabilities and the remedies that are available to successful plaintiffs. So let's begin. So we're going to talk about the process. We've got the vocabulary hopefully in hand, and now we'll talk about how the process proceeds. And we'll see it's very similar actually to the process that we use for religious accommodation. Um, the EOC has some guidance. Of course, the first thing that has to happen is the employer has to know that there is a disability and that there needs to be a reasonable accommodation. An employer is not required and, in fact, should not try to find out what people's medical status is. Now, of course, sometimes it's obvious. You have somebody who comes to work in a wheelchair or comes to work with a cane. It's pretty obvious that that person has a disability. So an employer that kind of turns a metaphoric blind eye to a situation isn't going to be in a legal good spot. But when an employee has a condition that isn't obvious, well, under those circumstances, it is really on the employee to raise the concern. But the employee doesn't have to do it in a particular way, doesn't have to use any kind of magic words, doesn't have to mention the Americans with Disabilities Act, doesn't have to use the word disability, doesn't have to use the term reasonable accommodation. In most cases, probably the employee isn't going to use that kind of vocabulary. And so it falls upon the employer to recognize that this is a request for reasonable accommodation. For this reason, it is important that supervisors and managers be trained to recognize when this type of request is being made. Now, it's probably a best practice not to have that supervisor or manager make a decision about the reasonable accommodation. That's something for the HR professionals and legal professionals to resolve. But if you don't train your supervisors and managers to recognize a request when they receive it, then they may just dismiss the request and say, oh, this person wants special treatment. Or, oh, this person is just saying, wouldn't it be nice if, but we all know it can't happen that way. And then not escalate that concern to the right HR person. So the first line management and supervisors need to be aware that this is a legal obligation and that they do need to escalate the matter to HR. And of course, there will need to be an interactive process once the employee brings that to the attention of somebody in the organization. And the interactive process can look lots of different ways. Part of it's going to turn on the particular employee circumstances and the employer's size and its concerns. There may initially be some time that needs to be spent to confirm that this, in fact, is a disability. And that may be the first stage in the process. And then after that, you may move to a discussion about how to reasonably accommodate. Sometimes it may be obvious that this is a disability, and so you can move directly to the reasonable accommodation situation. Sometimes the way to reasonably accommodate may be obvious, so there doesn't have to be a lot of discussion about that. It may be clear that a special type of keyboard is necessary or special type of monitor is necessary. And then it's just a matter of picking the particular model and ordering it and installing it when it comes in. Other times there may be a need to be more creative, so there may be a need for folks to research the matter. Or there may be a difference of opinion between the employee and management about what is the best reasonable accommodation or what's going to fully accommodate the needs of the employee. And so it kind of depends upon how the facts develop, whether this is going to be, a quick 15-minute conversation where everything gets resolved, or whether this might be, you might have 5, 6, 7, 8 conversations. It might require some lengthy negotiation back and forth. And so it's important that whatever the process is, that the employer document it carefully. This is going to be the HR professional, but in smaller organizations, it might be a line manager. And so what that manager or the HR professional would want to do is document the date, uh, who was present, what was discussed, and what action steps were, and then what was the plan for the next meeting or the next set of discussion. The notes should make it clear that the employer was receptive and was prompt in responding to that concern. That should definitely be a tone that is advanced. You don't want the notes to make it seem like the employer is being reluctant or only doing this because it has to or trying to do the absolute minimum. That's not the tone that you want the notes to convey. You also don't want the notes to convey an adversarial spirit, especially not at the beginning. The tone that you want for the potential jury or judge to see is, well, this employer was trying to do the right thing, and if something later on happens that there isn't an ability to reach a consensus, well, at least the employer tried. You're always looking to these notes as if they are going to be the main exhibit in the trial about a failure to accommodate the ADA person. So, you really kind of want the notes to be as complete as possible. If they're handwritten, as neat as possible, covering all of the information about the meeting. Uh, so that is an important part of the process. I like to say if you don't have notes about the meeting, it's like it never happened. The meeting notes certainly can be typed, but you want the notes to be as contemporaneous as possible. They may well seem self serving if they're prepared weeks later. And so, yes, you might choose to type them up after the meeting, but you'd want to get that finalized within, say, 24 hours, certainly no more than 2 or 3 days after the meeting. And I'd probably go ahead and keep the handwritten notes. Maybe you'd scan them into your computer so you have those as well as the typed notes. Uh, here we're talking more about that initial communication that the employee makes. So the employee needs to, first of all, share some information that would lead the employer to think, this might be a disability situation. And then hear what the employee says about what kind of accommodation is needed. Now, the employee might present it as a problem. Hey, I can't do X. Uh, what can we do about that? Or it can be presented as this is what I need. In other words, the employee is presenting a solution. And then, of course, you might approach those differently. For example, if the employee is presenting a solution, then the question is, well, why do you need this? What is the problem that this is going to solve? And it may make sense to say, what are some other solutions that might also work? So those are some strategies that the employer may want to consider. You want to obtain as much information as possible about the condition. Sometimes people get a little squeamish about things like this, and they may think, oh, but HIPAA's in play or something along those lines. It is true that there is the need to be sensitive and to handle the matter confidentially. And I wouldn't ask questions that really aren't relevant to the working environment. But it is very appropriate and, in fact, required to ask questions to make sure that you can, number one, see if this is a disability, and number two, see how this disability can be accommodated. So it's very appropriate to have those conversations. Now, obviously, the notes about those medical issues should be handled in a very confidential manner. And typically, these notes are not going to be kept in the personnel file. You're going to keep them in a separate folder that is just about this particular matter. Then you're going to discuss alternatives. And again, at this point, you're not saying yes, you're not saying no to them. You're just saying, well, let's talk about possibility A, let's talk about possibility B, let's talk about possibility C. And again, the employer isn't saying which one it's going to go with, it's just exploring options at that point. And again, you want to document the process. And the process may involve conversations with other people. For example, you may need to have discussions with the employee's doctor. You may need to research various products that are available. Do a little bit of Amazon searching or other supply companies' databases to see what products are available. You may need to talk to an architect or a building contractor to see how you might need to make some changes to the physical layout of the facility. It is appropriate to request medical documentation if that's necessary. I've been in situations where it's worked out that we have requested it. I've also been in situations where it really wasn't necessary. It depends upon the circumstances. Naturally, if there's some suspicion that this person may be exaggerating their condition or maybe they don't have the condition at all, it's very appropriate under those circumstances to ask for documentation. If there is a lack of clarity, maybe everybody gets that this person has this condition, but there's a lack of clarity as to the specific limitations of the position or the specific requirements this person might have. You might need more than just a description of the disorder, but you may need to have a give and take about, well, would this be adequate to solve this particular employee's needs, or would we need to do this to make sure that the particular situation is being addressed adequately? So while there's lots of things that the employer can be required to do as an accommodation, one thing that employers don't have to do is they don't have to violate the seniority rights of other employees. So let's say this particular employer has a union contract, a collective bargaining agreement, in other words, and that agreement requires that there's a job posting system. And the people who are promoted are the people who have the most seniority. So let's say you had Bob and Susan applying for a job. Bob has 12 years of service, Susan has 11 years, but has impeccable appraisals. Bob has okay appraisals, they're fine, but they're nothing great. Management would really prefer to promote Susan. She's such an awesome worker, and she has almost as many years of experience as Bob. But under the terms of the collective bargaining agreement, Bob is supposed to get the job. Well, then Bob is going to get the job. Let's assume in this scenario that Susan has the disability. And her current job, she is not able to continue to perform the essential functions of it with or without reasonable accommodation. But this new job would be perfect for her. She would be able to perform those job responsibilities with reasonable accommodation. So not only do you get to promote your preferred candidate, you get to reasonably accommodate someone with a disability. Unfortunately, though, or excuse me, if the employer, the union almost certainly is not going to go with that, and so under those circumstances, the employer is very likely to go with Bob. Now, let's say there wasn't really a collective bargaining agreement. Let's say that there was just a well-established procedure in this particular non-union facility that it would ordinarily happen that Bob would be the one who'd be promoted. So even though there is no contract in this workplace, seniority has high value, and everybody understands that Bob is the one who's going to be promoted. Under those circumstances, the employer would not be required to promote Susan before Bob. Can the employer overcome seniority rights? Yes, the employer can say, we would prefer to promote Susan over Bob. Now, obviously, Bob is not going to be happy, but Bob doesn't have any reverse discrimination rights. And there isn't any union that's going to be able, or any union contract that's going to be able to challenge that and say, well, this contract has been violated, because there is no contract. So an employer can overcome the seniority rights of Bob in this scenario, but wouldn't have to. And most likely, if you had an organization that really followed seniority, you're probably still going to follow it in these situations. If you have an organization that usually follows seniority but sometimes doesn't, that would be a situation in which you might want to seriously consider giving the position to Susan instead of Bob. Obviously, our accommodations need to be fact specific, so you don't want to use a cookie cutter approach and say, well, we had another person who had a similar situation, and this is what we did for that person. I mean, that experience can be useful, and it may well apply, especially if the job is the same job. But it may also not be sufficient. It may be that this person has a more severe condition or needs a different type of accommodation. And so you always need to look at the particular person. Again, it's that fact intensive, that individualized assessment. And of course, it's also going to vary from employer to employer. So the fact that, let's say, this employee used to work down the street and what they did at that particular facility was X, it doesn't necessarily mean that the employer that he or she is now working for has to do the same thing. Again, useful information that may make sense, but it may also not make sense. The employer isn't required to do what has been done before. It's also the case that the employer isn't required to continue to do the same things that it has done in the past. An employer might offer, say, an employee extended breaks, uh, but then decide after a while that that is negatively impacting morale. And so the employer might be able to reasonably accommodate the employee without using extended breaks. Again, the medical need needs to be accommodated. If the extended breaks are a requirement for the medical needs, then that would be an appropriate response. But it might be that there's another way of accommodating that. For example, instead of extended breaks, maybe providing a chair for the employee to have while he or she is working might be sufficient to meet the medical need. And so just because the employer for a time is given a very generous benefit, it doesn't mean that there can't be a change, perhaps reflecting some change in the operations of the company. Or perhaps it doesn't reflect changes in the operation of the company. As we said before, the employer never has to reassign essential functions, but there certainly can be a negotiation process. Again, let's go back to our example that we talked about in the last scenario. I'm a secretary, and in my position, I spend most of my time with these essential functions. Let me get a pen here. So this is my chart. So here I'm typing, just put a T here, and here I'm filing, and here I am, we'll say I'm a receptionist, maybe half of my time. Well, there's another secretary, we'll say his name is Bob, who has a similar division of work. But it ends up that because of my disability, filing really isn't something that is likely to be very workable without significant changes. The filing cabinets we have, let's say I'm restricted to a wheelchair. The filing cabinets we have are very high, and I wouldn't be able to use them in a wheelchair. And it would take a lot of buying of new equipment and reorganizing all those files to make them accessible to me. And so it might be discussed with me, hey, what if we take your file responsibilities, give those to Bob, and we'll give you Bob's typing responsibilities. And let's assume they're roughly equal. And so you will be the typist for your attorney or whomever you happen to support, your manager, as well as Bob's manager. And Bob will be responsible for filing for your manager and for Bob's manager. Again, it's not necessary to get Bob's agreement to this, but it's probably a good idea to talk to me, the disabled person, to find out, well, what could be the issues with that? Perhaps I might say, well, that much typing would be too much for me because of my medical situation. So you want to brainstorm with the person so that they can identify potential problems with the solution. There may also be issues like, well, there's a lot more typing than there is filing, or maybe there's a lot more filing than there is typing. And so there may need to be some adjustments over time, depending upon the workload, or initial adjustments to reflect the difference in the workloads. Um, uh, Bob should also probably, and the managers ought to be part of the discussion. Again, Bob doesn't have a veto, but his feelings about this topic, maybe he will be able to brainstorm and present other ideas. Again, confidential medical information shouldn't be shared with Bob, but information about what some plans are certainly can be. And you can get Bob's kind of temperature as to how he's going to react to this. He doesn't get a veto, but it's not best for the working environment if he's seething in anger because of this change that he had no opportunity to comment upon, and that he feels the other person is getting some kind of special treatment. So you want to be careful about that. You don't want it to seem like Bob gets a veto. You don't want to share medical information with Bob, but including Bob to some extent in the process when it's going to significantly affect his job responsibilities can be a good strategy. You want to approach it with, Bob, these are some thoughts of some changes we're going to need to make. I want to get your thoughts as to how we should implement these changes and if there are some aspects of this change that we haven't thought through adequately. That would be a good way of approaching it with Bob. I'm going to go ahead and erase the ink. Another thing that an employer doesn't have to do is offer paid leave, at least not to the extent that they have to offer more paid leave than non-disabled employees would receive. So if I'm disabled and I need to take some time off, I should be allowed to use my vacation or PTO time as well as sick days. And there may be some other types, categories of paid leave that would be available to me. Again, those would be available to non-disabled people. Let's say that every employee has 20 of those days a year. Well, once I get through those 20 days, on my 21st day, the employer is not required to make any more days paid, but I may well be entitled to unpaid leave that extends beyond the 20 days. Typically, for longer service employees, the Family and Medical Leave Act is going to kick in. And that's an unpaid leave. We'll talk more about exactly how that works in a later module, but generally speaking, there doesn't have to be additional paid leave. Um, could employers provide more paid leave? Sure, but that probably isn't a good idea uh, to give additional paid leave because of the morale implications for your non-disabled workers. That is something that may well create some bitter feelings there. It used to be the case that many employers had what was called a no-fault attendance policy. It kind of worked a little bit like no fault divorce in a way. The idea was that, look, we don't care why you missed work. You may have had a great reason. We're not even going there. All we know is we need you at work and you weren't here. And so when you have a certain number of absences, that's when we're going to use the disciplinary process. But we don't mean by this that we think you're lying to us or that you didn't have a good reason for not being here. We're just saying we need you here, you weren't here, here's the consequence. And many times in these situations, the employer would say, I don't even want to know why you weren't here. Um, those types of programs were called no-fault attendance programs. Again, kind of like divorce. If a couple wants to get a divorce nowadays, they don't even have to give the reason. They don't have to say there was adultery or abandonment or abuse. They can just say irreconcilable differences. And the judge is going to say, okay, if y'all want a divorce, I'll give you a divorce. I don't even need to know what's going on in your private lives. The divorce will go forward. Under those circumstances. So that was the old kind of no fault attendance policy. That has really ended both because of the Americans with Disabilities Act and the Family and Medical Leave Act. Because under those laws, you can't usually consider illnesses, at least many illnesses, for attendance policy. So let's imagine that I miss some work because I have an unreliable car. It breaks down regularly. Well, again, that's not a medical reason. There's no protected category for people who have unreliable cars. So under those circumstances, an employer would be absolutely free to take disciplinary action against me. But let's say instead of it being an unreliable car, let's say because I have um, Crohn's disease, there are several days a month that I am just too ill to go to work. And so I need to be home at those times. And so let's say I miss 3 days last month to Crohn's disease. I've missed 4 days this month for Crohn's disease. According to the attendance policy at my place of employment, that means that I should receive some kind of disciplinary warning. Well, because it's due to my Crohn's disease, which is very likely a disability, and if I meet the service requirements, would also be a Family Medical Leave Act event, the employer shouldn't be counting those days against me for the attendance policy. My bad car, yes. My runny nose that lasted 1 day, uh, yes. The fact that my Aunt Lucille, I had to visit her in the hospital. Yes, that can count, but not my own personal illness, especially when it's a disability. And so as a result, it's important that employers know not just that the person was absent, but the reason for the absence, and not to count reasons that are prohibited. We'll talk a lot more about the FMLA and how that works in terms of attendance policies when we get to that module. An employer definitely may need to alter the work schedule to accommodate medical appointments or possibly the disability itself. I've had situations where a particular employee, because of medication, would be more alert, more clear headed at certain times of the day. And so those were the times of the day that he wanted to be scheduled to work. And so that can shift the workday. Or maybe the flip side of it, the other times of the day he would be foggy because of the medication he was on, and that wouldn't make sense. You could have a disabled person who needs to rely upon public transportation to get from his or her home to the office. And it may be that the public transportation won't get him or her to work until 9:15. Well, then 9:15 would be an appropriate start time under those circumstances. So you want to be sure that you're considering all those issues. A person who is on dialysis might need to have every Wednesday off for dialysis treatment. Or a person who is going through a chemotherapy might need 4 or 5 days off a month when he or she is receiving the chemotherapy dosage. Generally, an employer is not required to allow a disabled employee to work from home if non-disabled employees don't have this option. Now, I think as a result of our experiences with COVID-19, this may be an area of the law that's going to change because it seemed to become easier for employers to manage people working remotely than many employers had anticipated that it would be. Now, it still remains the fact that many jobs can't be performed remotely. You can't be a chef from your home. You can't be a typist from, well, you can be a typist from home, but you can't be a waitress from your home. There are still jobs that do require that you be physically present. And so certainly those jobs, you can require that the person be there. But if it truly is a job that can be done from home, yes, right now the cases say that if the employer doesn't usually allow it to happen, you can't insist that the employer do it for disabled people, but the employer definitely can do it for disabled people, even though it doesn't do it for able-bodied people. And as I said, I think in many cases, it's going to be difficult for employers in the post-COVID-19 world to say they can't use as a reasonable accommodation if they allowed a significant portion of their workforce to work from home for a significant period of time. And again, there may be the need to modify certain aspects. It could be the work area. If it is a cubicle, maybe you have to broaden the entrance or make the whole area larger or change the height of the desk so that the wheelchair goes under it uh, comfortably so the person can get close enough to the keyboard. You may need to change break rooms, make a locker that's accessible, put in ramps or elevators. Bathrooms can be issues if there isn't a handicap accessible bathroom. And even if there is a handicap accessible bathroom, this particular person's handicap may be different and may require a bit different solution than the generic handicap accessible bathroom. There also needs to be access for the employee to all of the spaces that are intended for employees in terms of benefits. For example, the cafeteria, the break room, um, the employee workout room. If there's a employee dry cleaners, the disabled person ought to be able to access that. If there's an employee workout facility, the disabled person ought to be able to access that. And so working through not only how they can gain access, but how they can use the facility is necessary. Obviously, if there's physical changes that have to happen, those aren't going to happen in a minute, but they need to happen in a reasonable pace for the facility. Okay, so here are some recommendations from the EOC about how this reasonable accommodation should work. So again, if the employer hasn't already done so, the employer should examine the job and figure out what the essential functions are. In many cases, this will have happened through that position description process that we talked about in the last module. But if it hasn't happened yet, then this is a good time to make it happen. And if you happen to have a very generic position description, you may need to get more granular here. Now, this isn't just any secretarial job. This is a secretary to Bob. And what Bob wants from a secretary is a little different than what Susan may want from her secretary. Again, it may be, or it definitely is necessary to talk with the person with the disability to find out what the limitations are, at least as how those limitations affect the working environment. And then discuss again candidly what are potential accommodations. It's ultimately going to be the employer who makes the final choice about what accommodation is. It doesn't have to be the one that the employee prefers, but it does have to be one that does accommodate the complete disability so that there is no unmet needs under those circumstances. And a good guiding principle here is good faith. The employer is trying to find out what the employee needs and is trying to meet the need. It shouldn't look like the employer is just going through the motions, not really adding anything to the discussion, and is doing the absolute minimum. So here are some things that to keep in mind. The employee may have a preferred option. The employee may want the Cadillac version of this particular software that has all these bells and whistles, and that's also very expensive. But a stripped down version with fewer bells and whistles may well perfectly or adequately meet the employee's needs. It's understandable the employee wants the Cadillac. It's okay if the employer provides a Cadillac, but it's also okay if the employer provides a sensible Hyundai. The employer isn't required to provide things for personal use, such as a wheelchair, a hearing aid, eyeglasses, but things that the employee needs for the work, like a ladder, a larger monitor, a special keyboard, those types of things the employer would have to provide. Um, Working conditions don't have to be perfectly equal. So let's imagine that the closest bathroom for that particular gender is one that would be very difficult to architecturally configure to meet this particular employee's needs. And so a bathroom that's still reasonably close, but not as close, is the one that is architecturally designed to meet the employee's needs. It might be that, 90% of the non-disabled workers of that gender use the closer bathroom. But it would be okay under those circumstances if the disabled employee had to go a little bit farther to go to the bathroom. Now, of course, a little bit farther isn't, a mile walk. And so it has to be reasonable, but that would be an example. The key thing is that the disabled employee has a bathroom facility that meets his or her needs and that is reasonably close. So here are some examples of accommodations. Adding ramps, making aisles wider, raising or lowering work areas, restructuring jobs. Again, we talked about that, moving the filing from one person to another. Again, we said that our example, that was an essential function, which you don't have to move. But you sometimes restructure jobs with non-essential functions. You may recall that I was the very occasional relief receptionist. Well, since that was not an essential function of my job, that easily can be taken from me and given to Bob without any issues. Sometimes it's possible to come up with part-time schedules for a particular position. Usually, changing a job from full-time to part-time is not something that employers have to do, but sometimes that can make sense for the employer and for the employee. If the employee doesn't want to work part-time and that's not a necessary part of the accommodation, then usually it's not a best practice to make that person become part-time. Modified work schedules, as we talked about before, accommodating treatment schedules and medication schedules is important. Providing extra time for a test. This could be a promotion test or a higher test. This can make a lot of sense, especially when a person has a learning difference such as dyslexia. And again, you're going to want information from the doctor, or may not be a doctor, may be some other professional who would be able to offer their expertise. Software like drag and dictate or some other approach that will make the computer more available to the disabled person. And this is one that might be a little surprising, but employers do need to provide uh, uh, qualified readers and interpreters. This is especially common when you have somebody who is hearing impaired. And so to facilitate the communication, you might need to have somebody who is able to sign or who's able to interpret signing. So interpreting here doesn't mean somebody who doesn't speak English. Obviously, not speaking English isn't a disability, so that doesn't have any applicability to our ADA analysis. This is a tricky area. I'm going to tell you, in my experience, assisting people who are hard of hearing or deaf in the employment situation, as I have found to be the most challenging. Let me start by saying that my grandfather was born deaf, and so I know a lot about the struggles of deaf individuals, and I have a great deal of compassion for the challenges they experience in their lives. So I don't mean this in any way to be callous toward people that are hearing impaired. But one of the challenges that happens is that people who are deaf have many different ways of communicating. I'll give you an example. My grandfather was born in 1913. He went to the Texas School for the Deaf, which was a state school. And back then, the idea was to facilitate deaf children so that they would be able to enter the hearing world. And so there wasn't emphasis upon learning sign language because obviously you can only communicate with other people who know sign language, and most people who have normal hearing don't know sign language. So the focus was on lip reading. And my grandfather did know some sign language, and he was an excellent finger speller. So we were able to communicate with him through lip reading and through finger spelling. But uh, that isn't the way that people in a different generation, if my grandfather had been born in 1963, he almost certainly would have learned sign language as his very major part of his communication approach. So different generations, different models that were used would be applicable. Now, people who lip read, for example, um, they need people who can enunciate clearly um, so that they can read the lips. If somebody mumbles or doesn't make very clear lip movements, they aren't going to be able to understand what is being said. Um, so there can be challenges along that way. But even in that situation, no one who is lip reading is going to be 100% accurate with that. There are too many similarities between the shapes our mouths make to create different sounds for that to be kind of a foolproof system, especially when you're dealing with somebody who's speaking who doesn't have a lot of experience with enunciating in the way that you need to. So, for example, when my grandfather would have issues, oftentimes my grandmother would come along and his wife. She didn't know sign language, but he could read her lips very well because they had been married for a lot of years. And so the supervisor would talk to my grandmother, and my grandmother would hear it, and then she would speak it with her excellent enunciation to my grandfather, and he would understand it. And if there was an individual word that was unusual, she would write it out or fingerspell it. And that was the best way to communicate for my grandfather. It wouldn't have made any sense to hire a sign language interpreter because my grandfather wouldn't have understood the sign language interpretation. I suppose a sign language interpreter could have fingerspelled everything, but my grandfather would not have liked that. That would not have been a good way generally for him to communicate. But again, other folks don't know, many deaf people don't choose or don't want to or don't have the facility to lip read at all. There are other systems of sign language that vary. There are some individuals who have the kind of their own sign language system that may be based upon a family sign language, or it might be regional. And so one person's sign language isn't always the same as another. There can be dialect issues. And so sometimes having a family member do the signing can be better than hiring an interpreter. Of course, when you're dealing with a family member in those situations, there's always the issue, especially when there's signing involved, is what this person is signing, is it exactly what I said? And of course, the person signing it isn't a professional in many cases if it's a family member. So they may well adopt a casual, brief, they may be editing, I guess, along the way. Plus, you usually don't like to have family members present in these types of situations because let's say you're covering a disciplinary matter. Do you really want to tell the wife of your employee that the employee isn't doing a good job? That's not probably a very comfortable conversation for anyone to have. And so, for those reasons, a lot of times employers like to hire kind of independent readers or interpreters. But there needs to be kind of an initial discussion to make sure that interpreter is going to meet the needs of the deaf employee. This, again, in many cases, will need to be a continuing process. It's not a one time fix, especially in the example of deafness, because that need to have a translator is going to come up lots of times. And the deaf individual might say, "Oh, that translator you used last time wasn't any good. I couldn't understand what he or she was signing. Why don't you use this service instead?" Or why don't you try lip reading? Maybe that will work more. So those are some additional ideas that to keep in mind, to make sure that it's interactive, that you're touching base with a person periodically to say, how are things going? And again, because it's confidential matter, you want to do this in a confidential place and you want to document it. And hopefully the employee says, everything's great. Thanks for asking. And you can document that. But if the employee says, that was working at first, but it's really not working as well now, I think we ought to have another meeting. And then, of course, you have the other meeting. Okay, you aren't required, the employer isn't required to create a new position or to give someone a promotion. Now, obviously, if the person is applying for promotion, he or she ought to be considered just as anyone else. Also, the employer doesn't have to excuse or excuse misconduct, or uh, fail to discipline misconduct, even whether the misconduct is related to the disability or not. This usually comes up with drug or alcohol abuse and sometimes with mental health issues. A person might say, well, I have relapsed into my drug use. And as a result, he has come to work late. He reeks of alcohol. He isn't focused at work because of intoxication. Or if the person has bipolar condition, and again, this is by no means universal, but this could be an example, and the person is having a situation where maybe he or she is manic, and he or she is talking to a customer and says some outrageous or inappropriate things. That is something that the employer can address with the employee, even though that misconduct may be related to the disability. Obviously, if the misconduct isn't related to the disability, you would handle it just as you would any other disciplinary issue. You want to make sure, though, that if you're disciplining Sally, who is disabled for conduct X, that you're also disciplining Bob, who isn't disabled, if Bob is also doing conduct X. A disabled person is entitled to reassignment if she is qualified to fill a vacant position, even if she can no longer perform the essential functions of her own position. So again, you don't have to move the disabled person into a newly created position. You don't have to create a position for that person. But if there is an open position, you absolutely should consider that as a reasonable accommodation approach. Now, many courts have said that the disabled person ought to be able to jump ahead of other more qualified workers who might want that job but already have a job that they can perform. But in this case, this particular disabled employee is going to be out of work if a reasonable accommodation isn't found. And so there are some precedents for the idea that the disabled worker he or she will have to be otherwise qualified, but if he or she is otherwise qualified for the vacant position, he or she can move to the front of the line. But there are some cases that indicate, and I gave an example here with Huber, that the employer can still use the best qualified standard, and that may mean that the non-disabled person jumps ahead of the disabled person in line. And the disabled person may just be out of luck and be unemployed at that point. Again, before you apply the Huber idea, you're going to want to make sure that this is the current state of the law in your particular jurisdiction. So now we've discussed the reasonable accommodation process. Let's discuss some special categories of disabilities. I've already done a little bit of this, but let's continue on. So sometimes an applicant or an employee will have an intellectual impairment. And the usual standard that we look at to see whether an intellectual impairment qualifies as a disability is having an IQ below 70 to 75. The average IQ is about 100. So this is a person that has some intellectual limitations. Now, remember we talked before about somebody who had mild intellectual limitations, but they might have other disabilities. So we could be looking at somebody where we kind of combine the two. So maybe this person has an IQ of 80 or 85, but also has some other condition. Well, that person could still be considered disabled. The person under those, again, this would be an example of the IQ you'd be looking at if you just had the intellectual impairment. And you'd also want to look at specific things that this employee isn't able to do as a result of his or her impairment. And the usual rule is that the disability occurred before the age of 18. But let's say that a person had some kind of traumatic brain injury at a later point in his or her life. Does that mean that they can't have a disability stemming from it? Absolutely not. They certainly could have a disability that maybe is a result of a car accident or a disease of some type that has caused them to have an intellectual impairment. And so this isn't This doesn't mean that every single intellectual impairment that qualifies as a disability has to begin before the age of 18. Let's discuss psychological impairments. Obviously, mental health issues are very common. A quarter of our population has them. Not every single disorder or impairment is going to qualify as a disability. Some will, some won't. Obviously, in many cases, the employer won't know about a particular disability because the employee chooses not to share that information, either because he or she just chooses to keep it private, or perhaps because the employee doesn't feel like it's necessary, that it's not impacting the work environment. Disabilities are every bit as real as physical problems, and they are every bit as entitled to accommodation as physical problems such as a missing limb or blindness or something along those lines. Again, we already talked about the situation where a person who has mental impairment, not an intellectual impairment, but a psychological impairment, might have behavioral issues that express themselves. And so that can become difficult. Disruptive behavior in the workplace doesn't have to be tolerated, but should there be a little bit extra grace given to somebody who is suffering a mental illness and might have less impulse control than the average person? Um, Very possibly that should be a factor. Now, if it's, swearing at customers or getting into fights, no. But if it's not being as charming as maybe the person ought to be with a customer, uh, coaching might be the better approach. We talked about attendance earlier. We talked about the fact that certain jobs, attendance meaning physically being at work every day, may not be an essential function of the job. The EOC's position is it isn't an essential function for every job. It's obviously important, but there can be situations where you're going to waive attendance policies as a reasonable accommodation. Again, we'll see with the Family Medical Leave Act, you pretty much have to almost waive attendance policies for your long service people anyway. So the fact that the ADA also requires accommodation in this area isn't dramatically going to affect the world or the reasonable accommodation world in this situation. So this is a difficult area, um, especially when attendance is sporadic or can't be planned. When Bob needs every other Tuesday off work for his medical condition, that can usually be planned around. But the fact that Bob just there's no warning when Bob is going to have an episode, and so it's difficult to have a plan B to cover Bob's work for that day. These can present a lot of challenges. And typically in these cases, what you do is you dive into the case law and you see what your jurisdiction has done in this area. And again, you're very likely to get medical professionals involved in this to evaluate to see if this is reasonable under the circumstances. Okay, so let's talk about the topic of addiction. Here we're talking about substance abuse, alcohol, or some other substance. First thing to be aware of is that addiction of any type can be a disability. It isn't necessarily a disability, but there's a pretty good chance that if a person is an addict to heroin or meth or cocaine or alcohol, or to a prescription medication that he or she is abusing, that's very likely going to qualify as a disability. And generally speaking, the same rules that we've talked about in terms of reasonable accommodation are going to apply to somebody who has addiction as a disability, as long as, and this is super important, the person is no longer abusing the illegal substance. So we're not talking about alcohol here. We're talking about illegal drugs. Again, the heroin, the cocaine, the crack, the meth, the marijuana, whatever the particular substance might be. If the person has entered the recovery process and is clean and sober and is rehabilitating, under those circumstances, he or she will be protected under the Americans with Disabilities Act. So that is an important issue. Active drug use is not going to be covered. Now let's talk about the issue of alcoholism. Alcohol is obviously a legal substance for people who are over the age of 21. And so the illegal aspect isn't in play here. And so a person who is still abusing alcohol and is an alcoholic can have the protections of the Americans with Disabilities Act. But an employer never has to accommodate drug or alcohol abuse on the job. So, for example, if I am actively an alcoholic, but I have chronic tardiness because I can't get out of bed because I'm hungover, the employer isn't required to accommodate that. But let's say I'm still abusing alcohol and that is causing me to, let's see, what would be an example? I lost my driver's license, and so I have to take the bus to work now. I'm still drinking, uh, but I'm going to have to arrive to work 30 minutes later because the bus doesn't get there until 8:30, even though when I was able to drive, I was getting there at 8. That might be a reasonable accommodation. Again, you have to dive in and look at more specifics to know. Some jobs that wouldn't be a reasonable accommodation, but some jobs would. Hopefully, when you're dealing with addiction as a disability, the person is in recovery. Now, there is oftentimes an issue about, well, when does a person enter recovery? What is the threshold for that? If I haven't been using the substance for 24 hours, am I in recovery? Usually the answer is no. That's not long enough to really see if you're really going to be able to maintain this. But you don't have to be in recovery for months and months and months. I think a good rule of thumb is probably 30 days of recovery is sufficient to show, yeah, I'm trying. I'm trying to turn this around. And in that situation, whether you're an alcoholic or a drug abuser, if you're in recovery, you're going to be considered disabled. In many cases, the disability that needs the accommodation is going to be something like time off for treatment, for example, attending AA meetings, or perhaps not being required to serve alcoholic beverages. Let's say I'm a waiter. Let's say I'm a waiter at a restaurant that alcohol isn't a big part of the menu. It's served, but it's not common for it to be served often. In that situation, the bartender might be able to personally deliver the alcoholic beverages to the table on those rare occasions that one of my customers orders an alcoholic beverage. On the other hand, if I work in a bar and most of my orders are going to have customers that are ordering alcoholic beverages, then that wouldn't be a reasonable accommodation for me. So those would be an example of what could be reasonable and what wouldn't be reasonable under the circumstances. It is possible that those who got a prescription medication lawfully and then started abusing it, for example, taking more than the amount of pills they should, that because it wasn't an illegal drug for them, that they, while they're still abusing the drug, would be entitled to the disability protection. Again, I would look in the case law on this issue to make sure that in your jurisdiction, that's what the courts have been doing. It's not illegal to test people for illegal drug use. We've talked about that in a separate presentation. It may violate other laws, but it's unlikely to be unlawful in the state of Texas. Texas has permitted employers to do that pretty broadly. Both to have pre-employment tests, random tests, post-accident tests, those are usually permitted. Bans on intoxication at work or drinking at work can be enforced even against alcoholics if they are equally enforced against non-alcoholics. One thing to keep in mind is that many people who come to work drunk or intoxicated or reeking of alcohol or marijuana or whatever aren't alcoholics or they're not addicts. They just happen to have used too much alcohol that one time. So you shouldn't assume that somebody is an alcoholic because they smell of alcohol. Again, you may recall one of the categories, one of the three prongs of the ADA is being regarded as disabled. And so an employer should never assume somebody is disabled until that person tells the employer that that person is disabled. Sometimes what happens if an employee is relatively cagey in these situations is the employee will say, when they are being disciplined, either about smelling of alcohol or because of tardies, is they will say, oh, what's happening to me is that I'm an alcoholic, but I'm going to get into treatment. That's wonderful if that happens to be the case. The employee may be doing this in an act of good faith to be candid with the employer so that the employer is aware of what's going on, and that's laudable under those circumstances. But sometimes the employee might be doing that because he or she knows, now I'm raising the issue of a disability, and now I'm entitled to protection. Now, if the employee does it in the disciplinary meeting where you're not planning on dismissing the employee, now that you have that information, you have to look into it. You have to engage in that reasonable accommodation process to see, how that can be accommodated. Of course, if it's the discharge meeting and you've decided to discharge the person, and you go into the meeting and you've told people within your organization we'll be discharging Susan today, then the fact that Susan confesses to alcoholism or drug addiction or whatever, you can still go ahead and do the discharge. Where it becomes iffy is when the person who's doing the discharge hadn't completely decided whether it was going to be discharge or another chance. And maybe the person says, well, I'll listen to what the person has to say. And if the person, persuades me that they're really worth another chance, I might give it to them. And then in that meeting, the person raises the issue, I am an alcoholic or I'm a recovering drug addict. Then that employer really is in a position where he is probably not going to be able to dismiss under those circumstances. Is going to have to engage in that interactive process to seek a reasonable accommodation. So it's a good practice before you dismiss a person, before you go into that meeting, that you have all of your ducks in a row, you have all of your documentation ready, you've decided you're dismissing. Now you may have, you should always give the employee an opportunity to tell his or her side of the story in an earlier meeting before that decision was made to do the dismissal. But when you're doing the dismissal, it should be a relatively quick meeting where you cover the decision, where you collect the company possessions that might be under the control of the employee and you in the employment relationship. You don't want this to be an extended process. And so at the discharge interview, it's really just you telling the employee that the employment relationship is over. It's not going to be a situation where you're giving the employee another opportunity to tell his or her side of the story. As we said before, you can hold disabled individuals to the same productivity standards that you hold other employees. And oftentimes, as I said, the accommodation we're looking for is time off for treatment. It may be an extended time off, like an inpatient treatment for several days or weeks, or it could be time off for AA meetings or therapy of various types. Let's consider this scenario. So Monkey Co. Has discovered that one of its employees, Mary, is an alcoholic. And the manager realizes Mary's absenteeism is because of alcoholism. So the employer offers Mary some counseling services and also an outpatient treatment option. Mary participates, but it doesn't work for her. She continues to have the absenteeism that violates the company policy in this area. So Monkey Co. now offers Mary an inpatient treatment option. Mary refuses that option under those circumstances. Under these facts, the employer would be eligible to dismiss Mary because it has tried, again, it's engaged in that iterative process, that individual analysis, allowing Mary an opportunity to present ideas and to try various approaches before the parting of the ways. So this would be a reasonable action for Monkey Co. to take. But just to be clear on something, if Mary improves her absenteeism, but she's still an alcoholic, Monkey Co. should not force her into inpatient treatment. If her performance is fine, it's not Monkey Co.'s job to save Mary from her alcoholism. It's Monkey Co. should be focusing on Mary's performance at work. And if that's being impacted, then that's what Monkey Co. ought to be concerned about. I've already covered these before, so I'm not going to cover them again. But just keep in mind that some of these things you might have thought might have been a disability, but they are not under the Americans with Disabilities Act. And now we're going to discuss remedies. So we've talked about our special categories of disabilities. Let's discuss remedies. Again, remedies are what the plaintiff will get if the plaintiff is successful. And we'll see that they track very closely with what's available to successful claimants under Title VII. We saw with the Age Discrimination Employment Act that there were a somewhat different package of benefits remedies available to a successful plaintiff under that act. But the ADA goes back to tracking with Title VII. So the successful plaintiff is going to be, and this is assuming the successful plaintiff lost his or her job, so he or she'd be eligible for back pay, front pay, or reinstatement, not both, attorney's fees and costs, and if intentional discrimination is improved, compensatory damages and punitive damages. And the same caps that we saw with Title VII would apply. So the combination of compensatories with punitives for the very largest employers would be $300,000. Again, the availability of this relief is from the Civil Rights Act of 1991, and that particular act amended both the ADA and the Americans with, it did not, I'm sorry. It did amend the ADA, which is the Americans with Disabilities Act, and Title VII, but it did not change the liquidated damages provision in the Age Discrimination and Employment Act. So this is a Walmart case. I was in some sense talking about it when I shared some of the specifics about the deaf situation. This story is very familiar to me. I've seen many cases of this where we have a hearing impaired person who wants to have an interpreter, and it seems like the interpreter situation just doesn't work out. Various attempts are made. Maybe they were made in good faith, maybe they weren't made in good faith. Eventually, the employee is probably very confused because he doesn't understand what's going on. And one of the things to keep in mind with hearing impaired individuals is that, especially if they are hearing impaired from birth, is in some sense English is a second language to them or a learned language to them. And so even written English doesn't always make sense to them. Just like I can't read written Spanish or written French or written Chinese, a hearing impaired person who never learned English from hearing may not understand written English the same way that you or I would. And so sometimes writing doesn't even communicate the information clearly. So this particular individual, Amaro, may really not have understood what was going on, and it may well be that Walmart was retaliating against him for having requested to have an interpreter. So under these circumstances, the jury found that to be the case. And the jury awarded Amaro compensatory damages and punitive damages, and the court upheld that, saying, yes, under these circumstances, under the facts in this case, the managers who were making the hiring decisions didn't seem to understand that they needed to hire an interpreter, somebody who could communicate information that Amaro wanted to tell the employer and information the employer wanted to tell Amaro. Now, did Walmart have to have the employer at work every day? Absolutely not. But it might well be the case that that the interpreter needed to be there once a week, or often, several times a month. Could well be the situation. This may not be, this might could can in certain circumstances be quite expensive. Obviously, Walmart has a deep pocket. It's a large corporation, so it's going to have a lot of difficulty. I would say it can't argue that it would be too expensive for Walmart to hire an interpreter. But it's impossible, depending upon how much Mr. Amaro was earning, that the interpreter might cost as much as a significant portion of Amaro's earnings. Usually, courts don't consider that significantly relevant. The issue isn't is the cost of accommodation, how does it compare to the amount of wages that the worker earns? Instead, it's what can the employer afford to pay. You don't need to know the name of this case, but what I like about it is it shows you in a kind of a concrete example of the back and forth of how these cases proceed and how they can go wrong from time to time. So at this point, we have completed this presentation. In this lecture, we've talked about the reasonable accommodation process. We've talked about several special categories of disabilities, and we've discussed the remedies that are available to the successful ADA plaintiff. I hope that this presentation has been helpful for you. As always, if you have questions about the material, please don't hesitate to pop into my office hours. Thanks for your attention and have a wonderful day.